sign up for a conference at the end of this today, or it'll be posted on my door. But they're starting tomorrow, and I've got them through tomorrow through Sunday. Going to get through them, just do them. What I'm doing is you can either sign up individually or as a team. It's your preference, whatever you would like to do. Okay? If you have a time conflict, a problem with the scheduling, please just let me know and we can work something out. Okay? What's that? Yeah. Okay, so you can pick them up today, probably even before 2:30 actually, probably closer to 2. Make sure you sign up. So I'll turn it over. I'll give a brief introduction, but I'll let Jim introduce himself because he can do it better than I can. Jim Hinga, who was a very, very well-respected, highly esteemed trial attorney in Denver for 25 years.
29 years in one day.
And the thing I probably remember most hearing about him was being on the national trial team for the big 3 motor companies. So a pretty big hitter. I can let him. He can tell you why better than I can. Why he left litigation and is now doing mediation, arbitration. I've tried to talk to you a lot about real world stuff and the rising costs of litigation and that kind of thing. And so I thought this would be a great opportunity. I don't know that you get too much exposure to mediation and arbitration in law school, but it's becoming more and more important given the rising costs of litigation. So I had the good fortune of meeting Jim. I was a pretty young associate. I was probably about 2 years into my practice, and of course, was there one? Yeah. And at Holland, and you know, when you're a big firm, you don't get to do anything when you're like a 4th year either. So, but I got to do a mediation on a case, Teresa and I, and we were flying solo on it. We were having real trouble with the insurance company, and within about 5 hours?
Yeah, about that, 4 or 5.
About 5 hours, we got about double what we were hoping to get, and I put most of the credit on Jim on that one. So I had a good experience there, and so I thought it would be great to bring him in and let you hear what he has to say and questions. I know he's interested in your questions.
I want this to be very interactive. Number one, I can't talk for 45 minutes straight. If you have any questions, there's no such thing as a bad question. I started, as I indicated, 29 years and a day ago as a federal district court law clerk for a judge who just died a month ago by the name of Fred Winter. I was there for 15 months. I left and went into private practice at a firm by the name of White & Steele. Was there for 7 years, and then went to a firm, Baker & Hostetler, and was head of their litigation department. And that's when I started the national trial work. I was national trial counsel for 2 former asbestos manufacturers take the asbestos out of buildings and the personal injury asbestos cases. And starting about 1990, 91, somewhere in there, I was one of 5 lawyers on the national trial team for the Ford Explorer Bronco 2 rollover litigation. Had antitrust work, quite a bit of antitrust experience, quite a bit of corporate securities, quite a bit of commercial over the years. And I stopped practicing 6 years ago, mainly because I just couldn't do it anymore. When you're billing 2,600 hours a year for 15 years and flying 150,000 air miles every year, it sort of gets to you. It was fun for a while. But stopped practicing, went to DU, University College. They have an ADR program, graduate program, where you can get a certificate degree. They now have a master's program in conflict management if you want to stick around and get that. But it's 35 hours. I took that and got done with that not quite 5 years ago and started into practice, active practice as a mediator. Now, how many of you know, or how many of you think you know what mediation is? That's not bad. What do you think it is? Why?
Well, it's the mediator is a neutral third party trying to get the other 2 parties to resolve their own differences.
Okay. The neutral part is key. And there's a difference between neutrality and impartiality. I frankly don't think there is. My partner, Sam Gord, could lecture you an hour and a half on the difference. But the secret is to have a neutral person. And the mediator's goal is really to create a safe environment for creative communication. The safe environment in what I do, which is civil litigation, really is not a big issue, because you got usually 2 lawyers, 3 lawyers. Like today I had a case with 14 parties, 14 different lawyers, 14 different parties, and safety is really not an issue. Safety becomes an issue when you're doing divorce, when you're doing high conflict type of things, sometimes neighborhood associations, there can be an issue. But the safety is critical, because if you don't feel safe, you don't communicate. If you don't feel safe, you're not listening. The art of a mediator is to listen. And listen, you are all going to be taught as you go through your law school career to think judgmentally, to listen judgmentally. As I'm speaking, you're constructing an argument against what I'm saying. You cannot do that as a mediator. You have to be impartial. You have to be neutral. You cannot take sides. And I'll give you an anecdote. Very first role play I did in this ADR program over at University College, there were 4 males. One was playing a female secretary, one was playing a boss, and there were 2 of us as co-mediators. And the guy playing the lady secretary, and the issue was the secretary didn't like to get her boss's mail or coffee. It was very simple. He started playing the role in a very whiny, sing-song voice. And what ran through my mind is that, you stupid bitch. And I went, can't say that. Can't think that. You got to stay neutral. And it's been a very hard learn, after 29 years of thinking and listening judgmentally, not to come to those conclusions. And you may think it's funny. It is a challenge. It is a challenge every day. I just left a mediation 45 minutes ago where they were at $1.5 million paid within a week, or $1.6 million paid in the next 60 days. Now, the differential in interest is about $20,000. And the one guy, who's multimillionaire, he didn't want to pay the ones. He wanted 1.5, and then half paid now, half in 60, and they weren't going to do that. I just called for it, I left the car. It's still not done. So you get funny things fighting over different things. And mediation, at its essence, is listening. There's a class taught in the University College called Listening for Effective Communication. We listen in 8 different ways. I didn't know that, And as you take this class, it's eye-opening, because most of us don't listen very well at all. And you have to be open. You have to listen empathetically. That's one way of listening. You cannot listen judgmentally. You have to listen not only to the spoken word, but you've got to watch the body language. 80% of communication is nonverbal. And the mediation that I had with Chris, I watch people all the time. The federal district court judge that I work for, he was a very famous trial lawyer here in the state of Colorado. And he drubbed it into my mind, you do not take notes in trial. You watch. You're in the theater. You're watching the witness. You're watching the judge. You're watching the jurors. I never had a trial less than 2 weeks long. And at the end of 2 weeks, I may have 1 or 2 words written on a pad of paper. Because you have to observe and you have to listen. And that's what mediators do. We sit and we listen. I don't vest myself in an outcome. I don't automatically say, I want to get this case settled. I let the parties take it where it's going, maybe a little nudge at the edge, at the end. But you, starting your careers, watch and listen. Don't have your head down like this taking notes if you're going to be a trial lawyer. If you're going to be a tax lawyer, you better take notes. But if you're going to be a trial lawyer, no. So yesterday, I had a 2-day case. It was construction. mechanics lien foreclosure case. That's why there's 14 people. You have the owner, you have the general, and then you have all the subs who hadn't been paid. And I actually had an opening session where everybody went around the table, let me know what their positions were. And it was very interesting to hear the people, hear the anger in some of the voices of the contractors who hadn't been paid for 15 months. You could hear it. It was palpable on some of it. And mediator's job is to get rid of that anger. Get down to basics. Get down to this is a business proposition. So get there. Let me tell you how a mediation, at least in our office, and I think in most offices, comes about. Somebody will pick up the phone, and they'll call and say, is Jim Hinga available May 1st, 2003? And we go to the computer and say, yes, he is. Well, I want to book a case with him. Here are the parties. It's called the intake call. And if any of you ever want to have a career in mediation, the intake call is the start of you selling yourself, your credibility, and everything else to the group that's going to show up. It's the first interaction that you have with folks. Usually it's a secretary or a paralegal. Rarely is it the lawyer. But it's your chance to sell yourself right then and there, because if there's any hesitancy or any doubt on whether or not they're going to use you, you got to close the deal and you got to close it there. Now, that may sound mercurial, but you're in the business, if you're doing this, of making some money. And, if you're not mediating, if you're not killing something, you're not making money. It's not like being a partner in a law firm where you go on a sabbatical for 3 months and have other people do work for you and you get paid. This is a very straightforward, I'm not killing stuff, I'm not eating. So, may sound, it's a fact. That intake call, you want to get 3 or 4 key pieces of information. Obviously, the parties' names. Who are they? What are they? What type of case is it? Who are the lawyers? Where is the case in the litigation continuum? Is it just beginning? Has discovery taken place? Are you 2 weeks before trial? Are you a week before trial? Where are you? Because as you're taking that in, my mind is already starting to construct what the mediation is going to look like. I mean, if it's right at the beginning, everybody gets in a room, and I do a cross-examination of the parties. Very soft cross. I ask the questions, if it's a personal injury, how you feeling today? Does your neck hurt? Your back hurt? Whatever. So that I get a sense of where I want to enter the conflict. And there's a guy here that used to be here in town by the name of Sam Leonard that was one of the pioneers in mediation. He taught mediation classes. It's sort of a baseline book, artful title, Mediation. But he postulates that when somebody enters a conflict, and this can be husband and wife, this can be mother, father, and child, it can be siblings, you have to analyze the temperature of the conflict. He's got a 1 to 10 scale. 10 is thermonuclear war. 1 is interpersonal conflict. So somewhere along there, you have to make, as a mediator, you have to make an assessment of where the conflict is. And as you go through your professional career, if you choose a career where there are 2 outcomes that are possible, that could be tax law, that could be contracts, that could be negotiation, make an analysis of where the conflicts are. How big are the conflicts? How insurmountable may they become? And it's not a bad thing to do in your own life. If you're going to have a bitch with somebody, how bad is it? And what can you do to diffuse that? Also in the intake call, you want to know is there insurance? Is there not insurance? If it's a personal injury case, usually there is. If it's a business case, well, Chris's case was a T-bone motorcycle accident up in Boulder, where, I don't know, a husband and wife, or certainly man and woman, were riding on a motorcycle, and somebody blew a stoplight. They got catapulted 45 or 50 feet, a lot of road rash and broken bones. And a
permanent scar.
And a permanent scar, that's right. I forgot that. So, that's a pretty straightforward case. But for Chris, who was at the bar about a year, it's a big case. because you were in charge and you were doing it. But I made an analysis of really looking at Chris's clients. How badly are they not injured, but how badly are they tortured by what happened? They were a little bit. And if I recall correctly, the driver was sort of a callous fellow. But it was all about money and personal injury litigation. That's all it's about. There's a few other things. Basically, that's what it's about. But the intake call, you want to get as much information as possible. I have my new panelist. We just brought on 2 new panelists. I make them sit for 2 weeks and take intake calls, so that they're dealing with the folks. They won't be calling for them, but they're calling for myself or 1 or 2 other folks. Take the intake calls. Humble yourself to do this. Because the 2 new people we hired, they were big-time lawyers. I mean, big-time, 30-year lawyers. And it's a humbling experience to answer the phone and put yourself in what our receptionist office manager does. As part of my training at University College, I had to do an internship. And I ended up with about 60 hours, and I interned with a lady who was not a lawyer. She did almost exclusively divorce. She mediated at the kitchen table of her 100-year-old farmhouse. And for the first week, I did intake calls. I then went up and we had our second really mediation, and I had to cut the fruit and the cheese and do the crackers and make the coffee. And, at first I thought, what the hell am I doing this for? But then I realized that it's part of the training. It's part of you learn how critical it is that you need food, because you got to keep your strength up. And she was in Niwot, Pure Boulder. Over in the corner was a plastic waterfall that the water was always gurgling, that soft, easy stuff. She had every herbal tea known to me. But in about the 60 cases that I did with her, and this was pretty high tension divorce, nobody ever raised their voice, because she created a safe atmosphere for these people to communicate. And I mean, I had a lady who was about 6'1", 225 pounds, throw a coffee cup and knock her husband out. Had another guy bring a gun. Another guy went over to pick up his kids Christmas Eve, and Mama had a new boyfriend, so he pulls the Glock on her and sticks it in her mouth. It's fun. And I like high tension conflict. And there's a volunteer program. If any of you ever want to get into mediation, get my name. There's a guy by the name of Mark Loy, L-O-Y, I think, in Jefferson County. He is head of the Jefferson County Mediation Services Program. Jefferson County 1994, changed their barking dog ordinance from 2 complaining witnesses to 1. And when they did that, Poodle Court was overwhelmed with complaints. Puppy Court, so they had to come up with something, so they came up with this mediation services to do barking dog cases. And then gradually branched into doing everything. And it's a great training ground. It's the only place in the metropolitan area where you can get training, where you can get experience. So keep that in mind. It doesn't pay you anything. It's all volunteer. So, but as an anecdote, in the first 18 months that I was doing this, I was out there a lot because I didn't have paying cases. And my favorite day was every 2 weeks they had personal restraining order day. I was in county court, and half the room had a restraining order against the other half of the room. And it's 9 o'clock in the morning. Mama, who's got bilateral broken jaws because the Broncos got beat by Jacksonville in a football game, and Daddy had about a 12-pack. She wants Daddy to see the kids. So you have to mediate, you have to negotiate where they're going to see it, because the last place didn't work. The Mickey D's at 80th and Wadsworth just didn't work. So it's fun. It pushes your skills. Some of the conflict is so violent and so heavy, you guys probably have never witnessed it, never seen anything that intense. And I like that. It helps that I'm 6'5", 220 pounds, too. I mean, I can sort of keep rein on the table. But what happens is once they pick a date and a time, about a week before the mediation, I will get what is called a confidential settlement statement. It's under Rule 408 of evidence, and it's by statute, and it's by contract, and it's by everything. But what it is are the parties telling me what their case is. I want to know the strengths, I want to know the weaknesses, and I'll be candid with you. I told Chris this yesterday or today on the phone. His confidential settlement statement, the very first one that he did, was the most candid that I've received in 5 years. It told me exactly what you wanted, exactly what you needed. Now, that may have been because Chris had only been at the bar 1 year and hadn't learned how to bullshit yet. It was a very candid, straightforward, and very helpful statement. I see all kinds. I see where I know they're just blowing smoke at me. I see where they're very straightforward. Sometimes I just got delivered yesterday. I've got a case next Monday. I just got delivered 3 3-inch notebooks that thick, full of material to review. And I will read it, and I will charge for it. So down to, I've got a case Friday, it's a personal injury case. I got less than a page from the defense attorney. Straightforward, mid liability. Don't really contest damages. I just hope my adjuster has enough money to get the case done. Maybe, maybe not. I read the statements. If I have any questions, I call, because there is a statute in Colorado, mediation statute. All communications by and between the mediator are privileged. So when I pick up the phone and call somebody, that is part of the mediation process. The communications that occur there are privileged. When the folks come in the door, and I spend a lot of time, I mean, I've got a case going right now where the allegations are legal malpractice, bad faith failure to pay insurance claims, and some outrageous conduct and punitive damages. I've spent over 100 hours just talking with the parties. We had one mediation session that did not go anywhere, and we're still talking. Because the law firm wants to get the case resolved, the plaintiff wants to get some money, but they're $500,000 apart. But keeping the process of communication going is important. The folks arrive, and usually if it's a personal injury case, everybody in the room has been through the process, the drill before, except the injured party. They have not been through, and they're scared. You can see it in their eyes, you can see it in their body language. They're scared because they don't know what's going to happen. It's a new process to them. So what you try and do is, what I try and do is, sort of make it friendly. And in this town, there is a spectrum of how people do and conduct mediations / arbitrations. I'm very relaxed. I try and make it relaxed as possible. There are a couple judges who wear their robes to the mediation here in town, which is not very conducive to free-flowing communication, that safe environment that I was talking about. To folks who have my partner is very, very structured. He does the same thing every time. He's got an opening spiel that lasts 30 minutes within 5 seconds, plus or minus. He says the same thing every time, but he has never stepped in a courtroom. He has never been a trial lawyer. He graduated from here and immediately went into mediation. And that was 13 or 14 years ago. So he does not have, and change can drive him nuts. My son, who's 21, worked with us this summer, and every day he would go in and mess with something on my partner's desk just to get in his head. And it got him. It got him. And it was so funny to see the reaction. In fact, my son's here on spring break, and he was in the other day. He's got a picture of his wife, and one of he and his wife. My son turned the picture around towards the wall. This guy doesn't observe very well. It took him 3 days to figure out the picture to turn around. Anyway, you bring the people in. Some people, like Sam, has what they call an opening statement, and most domestic mediators have an opening statement. Opening statement sets ground rules. And when you have high interpersonal conflict, ground rules are critically important because it gives you the right as the mediator to enforce them. You also start by getting an agreement of both parties that they will abide by the ground rule, such as no finger pointing, no loud talking, you can't stand up out of your seat without my permission, no swearing, no cursing, no name calling, no button pushing, none of that stuff. If I see it, it's going to stop. And that's important because you're starting to create that safety that is there. Because if it's a divorce, the two dysfunctional people sitting in front of you obviously have not been able to communicate very well, or they wouldn't be at the table. So what you're trying to do is create that space where they can maybe let their guard down a little bit. Conflict can get so bad, you can be so conflicted. I had a case, again, out in Jefferson County. I got a call at 1 o'clock in the afternoon, Jim, can you come out because the mediator that was supposed to be here just had an appendectomy and is in the hospital. I said, sure. I said, what is it? Well, it's a property settlement and then parenting time. So I walk in a little lobby, and here is about a 55-year-old black man and about a 52-year-old white man sitting there. And I walk to the back room to this Mark Loy, and I say, I thought this was a property settlement. And he says, it is, between those two men out there. The white man had left his wife and 4 children to move in with his lover 10 years before, and they were just breaking up. So I had for the first 2 hours, property settlement between the two men. Then Mama, who had not spoken to Dad in 10 years, brings in 3 of the 4 kids. 2 of the kids had never talked to their father in their life. And I had to do parenting time. The 14-year-old daughter was anxious to get a relationship going with her father, so she asked her mother, I want to spend the weekends at Dad's. Now, they were sitting 5 feet apart. Now, this, again, is how conflict can just tear you up. 5 times she asked, 5 times the mother didn't acknowledge what the request was. I finally asked the mother, I said, could you please repeat back what your daughter just said? She couldn't do it. She could not repeat, I want to spend the weekend with my father. Okay? She couldn't do that. Why? Because she wasn't listening. She didn't hear. She was frozen by fear, frozen by conflict. Mediator's job is to get behind that. Is try and break that, just boom. And it's difficult. Some of us can do it very easily. Others just can't do it. My partner, Sam Gordon, he cannot do it. He is not good at that, so he chooses not to do any type of interpersonal work. And by interpersonal, I mean, employment, sexual harassment, racial allegations, workplace harassment, stuff like that. Those are the interpersonal type. And I don't have a problem with it. Some mediators will not mediate where there has been physical abuse. They just have their moral standard, they won't do it. Because they cannot be neutral or impartial. That neutrality and impartiality piece, when it comes to battering, whether it be male, female, male, they just can't do it. I made a choice early on. It doesn't matter to me. It just doesn't bother me. I'm not going to take sides one way or the other. I don't like people hitting people. But they have a need to have their claims or problems mediated, just the other folks. All right, the people come, they're at the table. Usually have, if it's a commercial case, I make the lawyers or the clients tell me what their bitch is. Because commercial cases, unlike personal injury cases, everybody knows what's going on. You know, they may value it here or value it there, but they know what's going on. They know. And it makes a big difference how you approach the mediation, whether or not these people want an ongoing relationship. If they want an ongoing relationship, there's a very high likelihood you're going to get the job done. Because whoever is alleged to have been the wrongdoer, if it wants to have this relationship, is going to bend over backwards to accommodate. Now, I usually go around the table, have them sort of tell me what they think their case is. That usually lasts 30, 40 minutes. Then we break into separate groups, 2, 3, however many parties there are. And then I talk individually with each one of them. And usually if it's a commercial case, I've already been on the phone with them, talking to them. Personal injury case, probably not, because you can read, if you get an in your back, and everybody has a fairly good idea what the value of that is. So they had their say. And you can just viscerally tell, and again, this is where the 29 years of trial experience comes in, viscerally tell whether or not somebody needs to vent. Do they need to really, for many people, this is their day in court when they come to a mediation session. Do they need to vent? If they need to vent, then vent. I'm a flak taker. Give me all the flak you got. I don't care. I don't take any of it on personally, but I will sit there and empathetically listen to them. And a lot of times, that's all that it takes. Then I'll go in the other room, and if it's personal injury again, and talk to the insurance companies, and they never have any money, and they don't care. And then we start what is called distributive bargaining, and that is money. All you're talking about is how much here and how much there. There's a mediation spectrum. Over here is facilitative. That means it's a needs-based look at the conflict. And just remember the famous philosopher, you don't always get what you want, but if you try sometimes, you just might find you get what you need. All right? That's needs-based. That is divorce. That is parenting time. That is employment. That is stuff, interpersonal stuff. And you approach it completely differently. You listen attentively, empathetically. You try and mirror back. Do I understand what you're really saying is, and then you mirror back what they have just told you to get confirmation that you are communicating with the individual. Over here is what I do. This is called settlement conference. This is where, I'll empathetically listen and all that other stuff, but at the end of the day, what they're really paying me money for is my 29 years of experience to tell them what their case is worth. So it's not quite as gentle, but that's what the bar has come to expect. Several ladies here in town and one man do divorce mediation. They are very facilitative. They are very good. And, can they do what I do? No. Their training and their existence won't let them do. But one of the teachers at DU that I had for, I don't know what class, she wanted to come and shadow me and when I started talking to the lawyers about the merits of their case, whether it was good, bad, or indifferent, you could tell she palpably was uneasy with that and had to leave the room. She was a very facilitative, need-based mediator, and she couldn't do it. So that spectrum, you have to figure out, if you're out in the real world, you've got to figure out what type of process do you want. Do you want over here, or do you want, the hammer over here?
Because that decision as a practicing lawyer, picking which mediator you want
is critical.
Oh, yeah.
It's, my style, I'm known for one style. There are former judges in town that are all trial judges. They've got a different style. They use that. I was a judge for 25 years, and I think you've got a crappy case, and then they go in the next room and say the same thing. And as a lawyer, you have to, the decision about what mediator to use is almost as important as what expert you're going to use, because different people have different strengths. I'm not real good at the minimal impact, soft tissue, personal injury cases. Where you got what's called myofascial pain, you got stiff shoulders, and flares up when stress occurs. I'm terrible at those things because I never did them. My partner, Sam Gordon, is fabulous at it because that's all he's done in his mediation practice are those type of cases. If you got that type of case, you want Sam Gordon over me. And that's fine with me. You can have all those you want. They're all the same. All the same doctors, all the same treaters, all the same injectors, they're all. Anyway, the process, I try and get money on the table as soon as possible if the case merits it. If somebody has to vent to me for an hour, then I don't get the money on the table for an hour. But generally speaking, I get the money on the table within a half hour, 45 minutes. Because what they're really there for is money. And you want to find out. And part of it is perceptual. A lot of times I've got to spend time with the personal injured party, disabusing them of what their attorney has told them about the value of the case. There's always, the worst thing a plaintiff's attorney can do, personal injury attorney can do, is overvalue the case and oversell it to the client, because perception, being reality, and it's everybody's reality, perception is what drives the bus. My job is to disabuse them if they have misperceived the value of the case. The case I had yesterday and today, the mechanics lien foreclosure, perception didn't mean squat. It's all paper. It's data. It's information. And it's amazing how people with the same data can come to different conclusions, but they do it consistently. And when I'm talking data, I'm talking, 1.5 million, 275,085 cents. And that 85 cents is important. And it's just a difference of how you do it. I had a multiple party. It was basically, it was an antitrust case, beer distributor, basically doing sort of floors versus Broadway stores and Pueblo bowling map type of flip-flop. And that was just the perception of the beer distributor. He thought he could do what he was doing, which is basically denying product because they were discounting prices. You can't do that. So that's floors versus Broadway stores. And so it took a little more because we had to deal with this guy who was a very sharp, very wealthy businessman who had to be told, and to a certain extent his attorney had to be told, you can't do this. This is against the law. And that took the better part of a half day while all other 12 or 13 people were sitting in the room billing time and having fun, not working. So what you do is, my job is to keep the process going. And if I feel, I shut the process down quicker than most people, because I don't think it's fair to a reasonably intelligent plaintiff, defendant, attorneys to try and keep it going if it's not going to go anywhere. If I know at the end of the day it's not going to go anywhere, why keep it going? My partner, on the other hand, he'll take $10 moves back and forth. It drives me nuts. But that's my style. As the teacher couldn't stand my style, I can't stand that style. We have, at the end of the day, what is called a short form of settlement agreement. Because of the confidentiality statute, because they sign a contract when they walk in the front door, agreement to mediate that has confidentiality in there, the last thing I want to do is be a witness to enforce a settlement agreement. I've had it happen. There's a judge up in Boulder. I was doing the personal injury asbestos cases, and the issue was whether or not an offer had a time limit on it. I talked to the plaintiff's attorney Sunday night before the Monday start. He said, I want $500,000. I called the defense attorney back, said he wants $500,000. Well, I'm not going to pay that. They pick a jury, and the defense attorney turns to the plaintiff's attorney and says, I'll take your $500,000. And at that point in time, since it was a lung cancer case allegedly caused by asbestos, and a woman had just lost her husband to lung cancer a week before, why she was still on the jury, I don't know. He wanted to settle for $500,000. I was ordered to go give testimony. And I told the judge, Judge, there's a confidentiality statute. I don't care. Come on up. And so I went up, and I thought that the issue was going to be, was there a time limit on the $500,000? That, in essence, was the issue. But we're not supposed to testify. So I have what's called a little short form of settlement, where I put in, plaintiff or defendant will pay the plaintiff, $100,000 within 14 business days, mutual releases, defense attorney to draft papers. Boom. That protects me. That is an enforceable contract. I always get the parties to sign it. I get the lawyers to sign it. So if they got a problem, just put it, that's Exhibit A to enforce the settlement agreement, and I don't have to go testify. Now, just a little bit about conflict. And I would go to the board, but I'm not very good at that stuff. Yeah, I will. There's a man by the name of Gehring, who's very influential in conflict management and communication skills. And I want all of you, when I'm writing these words down, to think about how you deal with conflict. You will fall into one of these 4 boxes. And I may not get them correct. Is it ENCE or ANCE? A? Cooperative?
Yeah, like Cooper at IBE. Said trial lawyers.
Yeah. Anyway, I want you to look at this. In your life, we have probably one major way of dealing with conflict. The cooperative is the best way. The worst is avoidance. Now, the classes I took at graduate school, they give you as mediators and you as conflict managers techniques. Yeah. No, wait, I'm missing one. There it is, competitive there. Avoidance, you don't engage. You don't even say yes or no. You don't even make eye contact. That's the most insidious way to deal with conflict because you're not dealing with it. But in your life, you probably have met somebody, if not you're one, who deals with conflict by avoiding. It's the ostrich in the sand approach. And me as a mediator, it's very difficult to get any type of resolution if I have an avoider. I had a divorce case, again with this lady up in the farmhouse with the waterfall. Man was there, had a baseball cap on, pulled it all the way down over his eyes. And he was not talking, he was like this, his legs were crossed. And I finally said, can you please take your cap off? Don't want to. Please take your cap off. I want to see your eyes. But I don't want you to see my eyes. I said, I want to see your eyes. I set the ground rules. Take the cap off or hit the road. So he took the cap off. Once he took the cap off, he became a competitive person. He wanted to win. Competitive means winning at all costs. When you negotiate, you're going to win. You're going to get the last say no matter what. And that's how you do it. It's not a particularly good way to negotiate conflict because you have to win at all costs. Which means somebody is either going to compromise, probably compromise. They're going to compromise what their needs are to the competitive person. May be okay, but not the best way to deal with conflict because you're giving in. You're just rolling over and playing dead. And at the end of the day, or the next morning when you wake up and you look yourself in the mirror in the morning, you're going to say, shit, I cut a bad deal and it's going to eat at you. You're going to have buyer's remorse. It's going to eat at you for a long, long time if you're cooperative. The best way, I had a divorce case this summer, a couple from Grand Junction, $15 million marital estate. Husband owned the patent, his companies owned the patent on the stuff, the glass that's in the aquarium. He's the only person in the world that makes that stuff. So it's a very valuable non-liquid asset. So my job was to figure out how to transfer liquidity to wife so that hubby could keep this job. They were extremely cooperative. It took 7 hours to do a $15 million estate. We had 37 agreements. And we just ripped through it. And at the end of the day, their divorce, once one of the lawyers drafted it up, cost them about $4 million. It's what you were talking about, the cost of litigation. they saved at least $50,000, if not $100,000, by doing it that way. But when you deal with this, when you see this, it's called Gehring's box. Keep in mind the next time you get in an argument or you got a conflict, how are you dealing with it? And this is just one of many of the little things. There is a class, if you're interested, up in Boulder. Name of the company is CDR. Used to be Colorado Dispute Resolutions. They train mediators. They train you to be a mediator. I took the class. It's about $1,100. They give it about, it's 40 hours. You're there for a week. We got great munchies, though. It's typical Boulder, great munchies. And that is sort of the gold standard here in Colorado. You have Harvard School of Negotiation, and you have Pepperdine University School of Negotiation. Pepperdine would be the nice place to go. The content that you get at CDR, though, is every bit as good as Harvard. It is. There's also a free University of Denver lady. I think she's already started, but for about $500, she has pretty much the same content over 5 Saturdays in the spring. Her name is Jo Marie Lisa, that she teaches a 40-hour mediation course. Content is almost identical to CDR, it just doesn't have the Pantia to it. Now, I haven't spoken much about arbitration. No, I haven't spoken at all about it. I do a lot of arbitrations. And when I say a lot, if you average over a year, I probably do 1.5 days of arbitration a week. Arbitration is more, obviously, you don't have any control. You turn the control over to 1 or 3 people to make the decision. That is the nice thing about mediation, is you as a party maintain control of the outcome. You say, you know if you want to say yes, you know if you want to say no. But you don't have a judge telling you what the world is going to be. Arbitration, at one time, well, prior to 1994, every one of the automobile insurance policies in the state of Colorado had arbitration clauses for their uninsured and underinsured motorist claims. State Farm did away with it. Farmers has done away with it. Some of the others have done away with it because here in Colorado, it's so conservative that they can do better in court than they can in arbitration. They can do better before a Boulder jury than they can in arbitration. So, I act as a judge. Again, I keep it informal. Theoretically, there are no rules of evidence. If you read the AAA guideline, I think number 30, or the AAA commercial rule, number 30, says there are no rules of evidence. Some arbitrators believe that there's no discovery. I'm of the feeling I'm not going to give full-blown discovery, but I want them to have something because I want at least a cogent presentation, so I'm not sitting there trying to figure out what the hell is going on. But arbitration is being preferred more and more. 80% of the commercial contracts in the United States have arbitration clause written into them. That's more for expertise than it is anything else, so that you can get a judge or an arbiter who works in the field, who knows what the field is. So that's why they're there. Quest has over 10,000 contracts a year, and they've just written in James Denver as the arbitrator. So, and they're binding. And there's basically four grounds for an appeal of an arbitration award. It's very narrow. It's fraud. It's biased by the arbitrator, miscalculation of money or dates or something like that, and that's it. So it's binding. It's over. Now, any questions? I said I couldn't talk for an hour. I did.
How much does it cost to mediate a case, an hourly rate, or?
Well, unfortunately, I still am the lowest hourly rate guy in town doing this, and I'm $250 an hour. I'm going to $275. Most everybody's at $3. Dick Dana and Bill Neighbors, they're 2 former trial judges, Supreme Court judges. They're $3.25 to $350. They started the mediation business here in Denver. So that's anywhere. Now, the lady that I interned with, who's not a lawyer, she charged $110. and she does divorce work. But generally speaking, you can get a case mediated for about $650. If there are two parties, it's about, I think it's $650 or $675 per side. They said, and the nice thing is, we require the money beforehand, so it's a great cash flow. Money just keeps coming in. But $675 usually gets 80% of the cases done. I have about an 80% success rate at the table or shortly thereafter. My partner has about a 95% rate at the table or shortly thereafter. So it works. It does work. It does cut down the cost. I'll tell you, if there wasn't mediation here in town, the court systems, it'd take you 6 years to get to court, at least 6 years. When I first moved here in '74, Denver District Court was 4.5 years to trial. Federal District Court was 9 months to trial. That is about flip-flopped. It's now about 4 years in federal court, and it's about 9 months to a year and a half in Denver District. Jefferson County, you can get a trial date within 9 months. Arapahoe County, you get a trial date within 9 months, but you will be reset 4 times, so it takes you 5 years, 6 years. Douglas County is overwhelmed. They're at a standstill. Boulder is pretty efficient. But if it wasn't for mediation, I mean, it'd just be dead. I mean, you couldn't move. And as an example, I have at least a case a day. Many days I have 2 cases, 2 half-day cases. 5 of the judges down at JAG are busy every single day. My partner is busy probably 3 times a week. So right there, if you just multiply all that out, there's 25, 30, 40 cases getting resolved a week that otherwise you'd have to run through the court system. So it's going to be, it is not mandatory in Colorado. Arapahoe County is the main open-door courthouse. They have 2 former Court of Appeals judges that scrutinize all complaints and answers once they're at issue. Well, once the case is at issue, 85% of all cases, civil cases, get diverted for mediation. 100% of all divorce cases in the 7-county metropolitan area must be mediated. You cannot get a hearing date in any court without having ADR somehow, someplace. Denver, probably 65-70% of the cases go in Denver. Jefferson County is the one county that really doesn't encourage mediation. They do, but they don't. Boulder is pretty active. Adams is pretty active. In fact, Boulder has an order that you cannot get a trial date until you have, and so does Colorado Springs, you cannot get a trial date until you have gone through ADR. Timing of ADR is critical. It depends on what you want. Boulder originally had within 90 days of the case being at issue. It was too early. You don't have any discovery. Nobody knows what's going on. So there's a whole spectrum. And without it, the system would just be a mess, more so than it is. And in fact, I don't know where you've been following this, if there isn't a no-fault bill put in and we go back to straight tort recovery, double all the cases in the court system. There will be a case for the liability, and there will be a case for the subrogated interest on the meds. And it'll just be hell. And my business will go through the roof. Anything else? Any questions?